this one sticks around. Well, Mr. Nordstrand, how are you?
Sure. Yes, excellent. Is he really? Environmental thing, right?
Good morning and welcome to everyone for our Community Justice Collaborating Council meeting. We do have a quorum and I greatly appreciate everyone's efforts in being here this morning. I'll dispense with roll call as we do have a quorum and Phil and I have made our notes. The minutes from the January 11 material or meeting was included in your materials. Are there any additions, corrections to those minutes? Hearing none, they stand approved as submitted. Public comment. I know we have a few folks in the gallery. Is there anyone who would like to make public comment this morning? Any request for public comment? Hearing none. Agenda items, treatment court update. We have both Judge Nordstrand and Kate back from maternity leave, and we welcome her back to her duties as our drug court coordinator. Kate, Judge, what can you share?
Go ahead.
All right, so with treatment court, since a year and a half ago when our numbers plummeted a bit with getting assessments, we are now almost fully up there. So we have 16 participants currently. We like to have 20 to 25, really around 20. Right now, in phase 1, we have 42%. So that's great. If we can keep kind of pushing them forward, we can get new people in. So from looking at it right now, we have 6 pending referrals. Some of them are looking great, so we should be full by the summertime, I would say. The one big thing that has been an issue is getting assessments in. So we're trying to work something out with behavioral health. If not, I've been in contact with Alex from Able Services, who would probably like to help. Also Birkwood. Birkwood is willing to come into our jail to help with treatment court assessments, also with the MAT grant assessments and any court orders that need to get done, and they can do them within a week.
I don't have a lot to add at this point. I'm glad to see that Kate's back, so that's a great help to the treatment court team and me in particular. I'm glad to see that our numbers are up. That's a very positive sign. I think we need to continue our outreach to the defense bar in bringing this up as an option for people. If I just look at the applications themselves, in other words, who's doing the applying, we used to get quite a few more applications through defense lawyers. And I know the public defender still does quite a number, but in terms of the actual members of the bar who are court appointed or otherwise proposing folks for treatment court, it's not very high. We get a lot of self-referrals, and those can be problematic because even if they're represented, they apply themselves, maybe sometimes unbeknownst to their defense counsel, and that creates trouble in the process. And not that we don't give them the appropriate consideration, but the applications are sometimes incomplete. Sometimes they don't even include the case number that they're applying under, and it makes it very complicated. So that's just a note that I think it'd be good to continue our outreach to the defense bar. In terms of the assessments, just to focus on what we're talking about here, in order to get admitted to treatment court, you need to be high risk and high need. And so our risk assessment is generally done through a tool called the COMPASS assessment. And our need assessment is done through an evaluation for their substance use needs. And so folks that are being proposed to treatment court on an ATR, that is an alternative to revocation, say they've been put on probation, something hasn't gone right. They are now in custody awaiting resolution of either revocation or otherwise, and they need to be assessed for purposes of substance use so that we can know whether or not they qualify. Those folks, we don't have a good way of getting them to assessment, and that's the problem. We're not talking so much about people that would be sentenced in traditional process, pretrial. They're pretrial, they may be out on bond. Most folks are. We're talking about the ATRs, so people who have been on probation, been unsuccessful in some sense, and now are looking to treatment court as an alternative to revocation. That's what ATR means. So that's the focus of, and there are quite a few ATRs that we consider. So that's the focus. The difficulty is that these assessments, the treatment provider we have for treatment court won't ultimately use the assessment, accept their own assessment. They aren't able to go to the jail where the folks are awaiting resolution because of their, I didn't understand exactly why, but I understand it has to do with they actually have to do their services in a hospital setting. So the jail isn't a hospital setting, so they can't go to the jail to do the assessments. So what that means is we have to have somebody else do an assessment in order to find out if the folks qualify so that we can ultimately get them out of jail and into treatment court. So just wanted to give an explanation of how that works and what we're working on. But other than that, I don't think I have anything else.
Any questions of Judge Nordstrand or Kate about treatment court? Just kind of as an aside, Judge Nordstrand mentioned the defense bar. Known to some of you, but the judges host a luncheon every February for our local bar association. And this year we hosted it in our new jury assembly space, which is just down the hall from where we're sitting now. We're very proud of that space, and if you haven't seen it and would like to, I'm sure Christy or I or someone else could show that to you. But we hosted that in February, and 50, 60 attorneys, I think, were there. It's amazing how many new attorneys are in the county, attorneys I've never seen before, but thankfully came up and introduced themselves. So Judge Nordstrand made a similar presentation to the bar about treatment court and trying to encourage members of the bar to consider that as an option. So just kind of as an aside. Yep. Phil.
I just wanted to take a second and acknowledge Kayla Stesniak, our treatment court case manager. Kayla, if you just give a quick wave. So Kayla took over treatment court largely while Kate was on maternity leave and did a really great job. And I really appreciate that because otherwise those tasks would have largely fallen to me. And so Kayla did 99.9% of that work. So I wanted to just acknowledge the work that she did. We are very, very happy to have Kate back, but Kayla, for 3 months, did an excellent job. So I wanted to acknowledge her.
Thank you. Next is Justice Support Services update, Phil.
Sure. So I think I'll just talk a little bit about pretrial for a second and some of the work that we've done. So again, we're continuing on this journey in pretrial of rebranding is what we're calling it. So again, going from this law enforcement model that the sheriff's office employed for 4 years, and then for the last now almost 3 years, we've had this civilian model. And we've gone through a lot of different changes, especially in the last couple years. I've asked the staff to endure a lot of change. Some of it may be unfairly on my end in pushing certain issues. But now as we head into, 2024 and 2025, our budget in pretrial really is starting to become solid. And the budget that we have now is the budget we will have moving forward. So one of the things that I've tasked the team with, that I'm largely responsible for, is the resources that we do have. How can we best use those and most appropriately use those to manage our pretrial clients? So the majority of where we, I guess I would say, allocate our funding is to drug testing. GPS monitoring and SCRAM, or continuous alcohol monitoring. And those are things that we will absolutely continue to do, services that we will continue to provide for the court. But I think it's important every so often to look at those resources and how we're using them and who most appropriately is being placed on those, and how we can continue to, again, serve the court and the wishes of all of the judges, but also be mindful of the resources that we have. And you know, one thing that we've continued to push in pretrial is a level of monitoring in the case management services that we do, because those don't cost anything. You know, those are, I'll say sunk costs, but that's personnel. And what we know about case management is that's how we affect change. That's how we can encourage and incentivize people to continue on a path of what we call desistance, so ceasing criminal activity, leading that crime-free life, whether it's recovery for substance use or mental health or otherwise. Case management is the change. So how we can continue to facilitate that, that's one of the things that I want us to look at in pretrial moving forward.
Thank you. Any questions of Phil about what's happening in Justice Services? A jail assessment, Kate touched on it, but I think we have Natalie Radich also here, who is going to talk to us about what's being done and how the county, I think, is interfacing with the jail to get assessments done.
So I really wasn't expected to talk about this today. So we have been, partnering with the jail to help out. We haven't been helping as much with the treatment court ones just because we've been trying to really figure out, again, like Phil had said, we only have so many resources and we're trying to be really smart about them. And if a treatment facility is already doing an assessment, we're just trying to be smarter about what will they accept or how can we work better with them instead of having 2 assessments because we don't have those resources. We're on a wait list over at BH, so we're just, again, trying to be really careful. But we are willing to help out. We do have a staff. Actually, her name's Alyssa. She used to work in the jail, so she seems to be like the best fit. She's super accommodating. She's flexible. She knows the jail. She's willing to do that. Also, I know Tim has worked diligently on getting that telehealth area set up, which I think will be amazing and it'll be really helpful. Right now, it echoes a lot, and it's just not the greatest space. But once they get that set up, I think that will help us a lot because you have to remember there's travel costs, travel time, things like that that just, again, aren't very efficient when we don't have a lot of people and time and things like that. So under that MAT grant, I believe there was about 3 allotted, 3 assessments allotted a month to be completed. So we're kind of working through that. One of the issues or kind of things that we run into is how do you prioritize some of these clients, because there are a lot of clients, some are self-referred. So what we've been trying to do is really focus on the ones that are referred from like probation and things like that, where we have a little bit of that collateral, we have, some more communication, and we know that it might help them out. And it's not just them referring, because sometimes when the clients refer, they have many, many barriers or things going on. Maybe I know a couple that have come up are facing multiple crimes and they're not getting out anytime soon. And so again, just trying to be smart and efficient with our precious resources that we do have.
So do you dedicate certain hours?
The way we're doing it right now, we're going through a lot of changes over at BH. So we're going to move in towards like a open model access or open access. We're not quite there yet, but right now our staff everybody kind of has a different role, but everybody has a few slots a week. Now they get taken up by court orders, they get taken up by people that come off the street, and they're like those high priority populations. Maybe they have children in CPS, maybe they're IV drug users, things like that, where they have to get in right away. So we have allotted time slots each week where people can get in, but as you know, they get taken up. Sometimes they don't get taken up, but now it's Wednesday, we had one Monday. So we just kind of have to shift, pivot, and kind of do the best that we can. So if there's a request today for a jail assessment. We might not be able to accommodate that for a couple weeks because we have other things going on, and we just try to be fair, firm, and consistent with kind of these requests, so.
Is Bill Scholl still assigned to the
Yep.
jail?
Yep, and Bill's doing great. Unfortunately, I did check with like ASAM, who drives our substance use assessments, and I checked with like our board. Unless he goes back to school, he's just not able to do those. Otherwise, that would have been amazing, because Alyssa was able to do that, and she was the predecessor, so.
And for those not familiar, Bill Scholes, I know because he was a child protection social worker for a number of years and now has kind of switched roles. So what, maybe just outline a little bit if you can, Natalie, what he's doing in the jail then?
Well, Bill has been very busy. There have been a lot of really challenging clients in the jail recently. So he's also helping out with Matt, which we've recently gotten up and running, and I know that's on for later. But otherwise, he just attends to the needs of the clients in the jail, which is kind of ebbs and flows, but it's been pretty high recently. So he will see, I don't know, up to 9 or 10 inmates a day and try to de-escalate them, you know, talk to them one-on-one. We provide coping sheets. We do have a Spanish-speaking inmate right now, so I know Bill is working with Claudia to get some forms, you know, put into Spanish for him because he's seen daily. So yeah, he stays pretty busy. There's a lot of needs in the jail.
Thank you. Judge Nordstrand.
Just a question to clarify, and my understanding of this is, what happens in November when the MAC grant runs out? Now, in terms of what you're talking about, is that impacted by the MAC grant in terms of these assessments being able to be done or not?
I hope not. Tim and I have looked, and it's called like a BJA grant. So there's a meeting on April 1st, and it's actually a really large grant. It was like $800,000. So I'm gonna go to the meeting, I'm gonna do some research, see if that fits. It looks like it will. We've also had some back discussion about maybe SOAR. SOAR is the state opioid response money. I've talked to those grant administrators. Other counties are using that funding for MAT in the jails. If we have that other source through the DJA, BJ, I wrote it on one of my folders in case I was asked today, but we might just do that. It's a larger grant. We were looking at proposing a caseworker, like another caseworker. Again, they can kind of be these gap fillers, but really to help support the jail and the MAT program itself, because when Kathy Borchatz was here, it was amazing to have her. And we see the needs of the jail ever increasing, and so it's hard. I believe it'll be hard for that person, Bill, to be able to do both, and we want this program to be up and running, and I think it'd be better to have somebody just allotted to that job.
So, but what I'm saying, and that's great information, I just want us to be aware that in the absence of additional funding or additional means to fund this, the MAC grant ends in November in terms of availability of assessment dollars, whether it be to assist treatment court or other individuals that need assessments.
Technically, yes, but we're like on top of it, looking for other grants to fill that gap.
And again, just for the better, MAT is the medically assisted treatment. Basically, it was designed initially to provide medications to folks with substance abuse when they're in the jail. So I know that's on the agenda. Phil, is there anything else you want to add on that?
Yeah, just real quick, Judge, thank you. So as maybe a broader overview, and I apologize, I put Natalie on the spot to talk about this. Thanks, Natalie. So I think there are, it's almost like a game of whack-a-mole, it feels like, with this project, where we take care of one thing and then something else pops up. Maybe that's not the greatest comparison, but so we have this grant money for the next 7 months, 7.5 months. That's wonderful, but then what? It sounds like we have other options, which is great. We have, Tim Kufis has ordered some telehealth equipment, which is wonderful, right? Because there are many players at the table here. We've got the provider, we've got the jail, we've got, the funding. So all of these different things coming together to how can we make this work? So to take a step back, when folks go to jail or prison, they oftentimes lose access to their health insurance. And we've got them, who they need to be assessed for treatment court or a court order. So they're sitting there. Right now we have the funding, but we don't necessarily have someone to do this for us. We have options, but we don't have a seamless process. but then we also have to consider the jail and their staffing and what works best for them. Is it a telehealth? Is it a non-contact? So we've talked about this, and we've had some really great discussions, and I think there are a lot of possibilities out there. But I would echo Judge Nordstrand's concern that starting on November 1, we don't have a source to fund these. And so that's kind of where I'm looking. I think we can absolutely make this work for the next 6 or 7 months, but then what? So that's kind of a very broad overview of what we're dealing with here.
Any questions of Natalie, Phil, Judge about jail assessments or the MAT grant? Again, I'm going to segue. Natalie mentioned that there was a Spanish speaker in the jail. Our population of Spanish speakers in the court system is growing exponentially. And I know it affects deputies and law enforcement officers out in the field when they're dealing with someone whose primary language is not English. It affects the courts, it affects the jail, it affects defense bar, anyone who's dealing with a population where, again, English is not their first language. To compound that, the provider that we use in the course for interpretation is a certified court interpreter, which has significance because we can get some reimbursement from the state if we use certified court interpreters. That provider has just notified Christie that her rates are going up significantly, and that those rates are going to potentially bankrupt Christie's budget for purposes of interpreter services. So we are going to meet with Christie to try to figure out, as a system, can we try to block certain time during each week when we'll do nothing but Spanish-speaking defendants who come to court, so we can maximize the resource associated with interpretation. We're going to hopefully have some of our more routine forms translated into Spanish. The state does some of that, but there are many other forms. Just, come back to court on this date. That we're going to encourage Christie, hopefully, to have our interpreter come up with Spanish-friendly written communication. But it's a growing issue, and again, primarily for Ken's ears, an issue that isn't going to go away in terms of budget, in terms of that resource. So, as a sum-sufficient budget, as I always describe the court's budget, we will spend what we have to spend. And I know Christie gets a little more excited about her budget, but quite honestly, we have to do what we have to do to administer justice. But that's something I think we need to be mindful of, is that population is growing, and it affects everyone in this room in terms of how we deliver services, how we interface, how we communicate. Testing services update, Phil.
Thank you, Judge. So as some of you might be aware, we did start offering testing, drug testing up in New Richmond at the Services Center last Tuesday, the 12th, and then this Tuesday, the 19th. So we've offered 2 different days of testing. So the plan is until the end of April, we'll be offering testing there on Tuesdays, with the idea that that first week in May, we will probably go to a Tuesday-Thursday schedule where testing will be offered in New Richmond, but not here at the Government Center, and then Monday, Wednesday, Friday, we will offer testing here at the Government Center. It seems to be going well. Each staff member in the department, myself included, will be taking 1 day over the next 6 weeks, and that will be our responsibility to test up there. So we'll be kind of an all hands on deck. But yeah, so far so good. I anecdotally have talked to clients who said, it's going to make their days easier by just being able to go to the Services Center and test. And yeah, any questions, feel free to reach out.
And again, I certainly appreciate the efforts that Phil and Mr. Witt and Behavioral Health, Building Services went to get that testing site up and running. I think, as I've mentioned, a significant portion of people who we test are from out county, as I describe it, not in the Hudson corridor, many of them from New Richmond. Many of the families who we test in child protection also then have the connections to behavioral health and to the service center, so having a testing site in New Richmond, I think, will really be beneficial for families, but also those individuals who are transportation challenged, as I describe it. And I have long said that when I retire, I'm going to start a taxi service for people who can't get to court and try to fill that void, Mr. Sartorius, that some of your clients have. So
I'll be happy to give you the referrals.
thank you, thank you, thank you. Any questions of Phil about testing in New Richmond or testing in general? TAD grant updates, Phil, Kate, Judge.
I'll just start, and then Judge or Kate, if you want to jump in. Just very brief, we have closed out 2023 TAD with the state as far as our reporting and funds being received. So we're fully into 2024. Our first quarter report will be due here in the next 3 weeks. The only other thing, and I'm just going to kind of tease this, and I'll let Lisa Maltoff from Diversion talk about this at our May meeting, is Diversion last week went through a virtual site visit for the diversion program from the TAD team. That's something that they're starting. They actually used our diversion program here as kind of a pilot site, which is, I think, admirable of the work that Lisa and her team do. So that's all I'm going to say, and then I want her to talk about it in May. I don't want to steal her thunder. And then at that time, she'll also have the report back from TAD. So yeah, things are going well with TAD.
And one for the next cycle as well. TAD grant.
Yep. Yeah. We're good through. So this 2024 is year 3 of the grant. So it'll become competitive again in 2027.
Any questions about TAD? Legislative conference for the Wisconsin Counties Association. Phil attended. Phil.
Sure. So just quickly, back in early November, myself, Supervisor Osnes, and Char Lopez attended the Wisconsin Counties Association Legislative Conference. It was my first experience there. I don't know if anyone around the table has gone before. It was eye-opening. It was enlightening. I think the biggest takeaway for me, selfishly, was it really has to do with our jail assessments. And knowing that other counties and then at the federal level, these discussions are being had, the struggles of getting folks services in the jail, specifically for substance use, because they lose access to health insurance. There was a gentleman from NACO, so the National Counties Association in DC, who spent some time talking about this very issue at the federal level and what does legislation look like so that people don't lose access to their benefits when they go to jail. And so there's no movement right now, but I'm hopeful that removing that barrier would allow folks who are in the jail, even if it's a quick turnaround, right? So we know on average people spend 11, 12 days in jails across the country. But even during that period of time, losing access to potentially medication or treatment or whatever it may be is really damaging to people. And so if that barrier is removed and we are able to get people assessed for SUDS, for treatment court or from a court order, I think that can help our system in so many ways from an efficiency standpoint. But then the folks that are in the jails or in correctional facilities, that the benefit to them is significant as well. So again, other issues, the governor spoke about some things. There was some discussion about treatment court. I know that the governor has signed on to acknowledging treatment courts as a huge function of the justice system. So if anyone ever gets a chance, I think the day-and-a-half conference is enlightening, and there are many ongoing issues surrounding the justice system. So,
any questions of Phil? Yes, Judge.
This might be an appropriate place to add in. There's some legislation that, of course, the sessions are essentially over at this point, and so whatever bills have passed. Many of them are waiting for the governor to consider. because I serve as the vice chair of the legislative committee of judges in the state, I was tasked to essentially lobby with the legislature about judicial security bills. There were 3 judicial security bills that had been proposed by the judges' legislative committee that had to do with picketing at judges' houses to try to influence them in case matters and prohibiting that, and keeping judge information confidential, address information, other personal information, and also keeping the form we complete for the sheriff regarding our security needs, in other words, things like my garage door password and things like that. There was some concern that they were public records, and so that somebody could simply request them and get copies of all of our information that was provided to law enforcement to protect judges as need be. All those bills went through the process and they both passed. I spent about 3 days in the legislature going door to door. It's kind of an interesting process, but we got it through, and they're waiting for the governor's consideration, and there's no reason to believe he won't sign them. There's an effective date that's out about a year, because some of the processes involving, say, keeping judges' information confidential at the Register of Deeds office and other things like that are complicated. So it takes a while to figure out how to do this. But anyway, I think it's a positive move, and it obviously follows on, the tragic story of the judge that was murdered some years by a defendant who he sentenced in Juneau County. So just one additional note.
Any question about legislation? Next, we're pleased to have Alejandro Diaz here from Able Social Services to enlighten us as to what the program is and what they can offer for the benefit of everyone sitting around the table. Mr. Diaz.
Yeah, good morning. Morning. Turn this up. It is on. Okay, perfect. Or loud enough. I don't need the microphone. But yeah, my name is Alejandro Diaz. Call me Alex. I'm from Able Social Services. That's my agency. And there's myself and other 5 people. I don't do this by myself. And we offer some of the services you guys have been talking about, the DUI classes, and domestic abuse classes and anger management classes. So I have currently 8 groups a week going with that. We also do the assessments for both programs, either the comprehensive assessment we use in the Minnesota side, and I'm just on the other side of the bridge in Stillwater, and the office is right there. And we also use the AOD or the AOD assessment that's been used for the Wisconsin clients. And that assessment is what approves people for treatment, like you mentioned, or if they don't qualify for treatment, if they don't meet the criteria for treatment, they end up on one of the education classes, like the DUI class, level 1, level 2, 1-day class. I also do the victim impact panels. And the domestic programs are anywhere from a 12-week program if it was a misdemeanor offense, or 18 weeks if it was a felony, or whatever probation requires to do. Because how the statute reads, at least in the Minnesota side, is 18 weeks, which is 36 hours, of probation discretion, which is either or. And the anger management classes are once a month. Victim impact panels are twice a month. In the the 1-day 8-hour class, and everybody does a victim impact panel usually when they do a 1-day class or a level 1 or a level 2 class. I also do the assessments for people who are in custody in jail. I connect with a county jail or the person who does the scheduling, and we set up a time in the phone, and we do the assessments in the phone. For the Spanish clients, as people who are being held for a little longer, if they usually have an immigration case or something that it has to be resolved before they do that. And attorneys are usually trying to resolve them quick to remove him from there before, if they get deported or something. So there's a much larger topic, but yeah, we do the assessments in jail. And I think somebody mentioned for having some of the forms in Spanish. If you do need help, there's a translation. Translating a legal form is not an easy task, but I do have somebody who can help you with that. And I am aware of the fees when they use, I don't know if they use a minute translation app. And here, no, I know it can get very expensive and you spend a lot of money really quick. So those cards that I got there from Phil, what it is for the referrals. They're both double-sided in English and Spanish. Because I know people comes and then they get released on the PO says you have to do A, B, S, C, 1, 2, 3, and people leaves out of the door and they forget everything that was said. So, and those will just mark assessment class or whatever is needed. So by the time I talk to them, either they speak, because we do the programs both in English and Spanish, we are half and half. So by the time I talk to them, at least they have a card in their hand saying, you need to do an assessment, you need to do a class, giving some guidance. And that way it eliminates sometimes with the approbation of whoever, because I spend a lot of time, and not especially with the Spanish speaking, I spend a lot of time, sometimes calling and seeing what services they need or what assessments they need. So that kind of helps expedite the process. On the website, and Phil, you can share the, I send you an email with 2 of the flyers, and the website is also a referral form that has all the same questions, and mainly who it is, what was the charge, and what they need. That they need an assessment first, or they need going directly into the class. And all the classes are done via Zoom. It has been since COVID, and the completion has been much, the percentage completion, because of problems with the transportation, people who don't have a license or don't have a car. So doing it online. And before I give people the access, I explain it really well how the class works, the privacy. You must be in the camera. You have to be present the whole time. You cannot have anyone around you. You can only miss so many classes before most of the people will complete the classes. So I make sure the privacy part is understood really clearly when they join the class, what they have to do to complete the class before I give them the access to the class. So, and I want to leave most of the time for questions. I know that maybe some questions how and the programs work, so any questions for me. And like I said, clearly the programs are both in English and Spanish. So it saves you once they get a referral for the Spanish clients, I take care of them, so it doesn't have to be a lot of need for a translator and doing the whole thing from the beginning till the final report, this person completed this class. And the treatment part, I know you guys been talking about treatment, but the assessment that assessment is the same assessment. It goes to the treatment facility to say this person meets criteria for treatment. And that is what approves either the insurance or the county funding to pay for that treatment, because they won't approve for treatment without an assessment saying he meets criteria for treatment, which most of the people don't meet the criteria for treatment. But for the ones that they do, they have to have the assessment for the consolidated funding for the county, or if they have insurance, they can go anywhere they want for treatment. And in particular for the Spanish people, I do have a few people that I refer for treatment that I know they will take in quick, because it is challenging to find that treatment in Spanish too. It's only 2 or 3 places that offer that. And most of those people don't have insurance because of the, the legal status, so they have to either self-pay or go through county funding, but county funding does pay for treatment, even if they're not a resident. Anyways, I guess just want to leave time for questions. And
I have a question.
Yeah, Randy.
Oftentimes, we run into the river being a barrier. Now, how does this work? Are you certified? Does the state of Wisconsin and the state of Minnesota, is this allowable between?
Well, I've been doing assessments for people here for years now, from the time that I met with the people from the diversion program in Kara. She called me yesterday, actually. She was a PO here, and she put me in contact with some other POs. So we do the Wisconsin side forms for the Wisconsin clients, just the AOD form. It's different than the one they use in the Minnesota side. It's a little shorter, but the recommendation letter, that's what it gets after the other evidence-based assessments. We use AOD, and other ones is AOD. And then we send the recommendation back to the referral source, PO, or the diversion program.
And you're open to general municipalities?
Yeah, well, I've been working with St. Croix County, Pierce County. Right now, they have a lot of Spanish people down by the past Wisconsin, the Trempealeau side. So I've been getting people. I think my information got passed down the river along the, so it goes all the way to the bottom. So I have people from counties that I never talked to the people, but I think they got the information from there.
Thank you.
Yeah.
And my question is going to be, Craig, is DOC using this agency? Do you know at all?
Yes, we are.
Okay. Okay. Other questions of Mr. Diaz?
What is the What is an approximation, out-of-pocket, no insurance, cost to them to do an assessment?
Is it $150 to do the assessment? Because they're not covered by insurance, so the assessment is self-pay, but if they qualify for insurance, the treatment and everything else is covered by the insurance. And I don't do the insurance myself, so I'm not, because that's a whole, I have my clinical license to do clinical work. I don't do that, because I would have to have a person just working for that. But anything that happens after the assessment, if they qualify for insurance, yeah, it gets covered by the insurance. So if I do an assessment in the Minnesota side, it's $175 for the drug assessment, drug alcohol assessment, and the one here is $150. Yeah, and all the other anger management and domestic assessments are also $150.
And then the estimated, usually approximation wait time for an assessment, if they call you, how soon could they get
If they
in?
call me today, myself and the lady that works with me, I'll have, in the next 2 weeks, I have openings. And once I do the assessment, it goes back to the referral source within 2 days. So they can decide. And if it's a Spanish speaking, right there, I ask for consent. Can I send this to the treatment place, which will contact you to start the treatment process? And they, like I said, there's one place in St. Paul now. They're doing really well. And for the people that don't qualify for treatment, they're right on the line. I use a lot of the free services to say, okay, for example, this person needs to do a DWC level 2 class, driving with care level 2. They have to do Mothers Against Drunk Drivers, but I add there, they should be going to an AA group once a week. They should abstain from alcohol, and I put there clearly testing with probation while in probation, because that's the biggest deterrent. Know that they cannot drink while they're in probation. And if they're going to drive, they have to have an interlock for like 6 months. And those are the people that are right on the line. They're quite not doing treatment, but sometimes I think that when I do the assessments, I believe they need a little more than just the education class. This is a difference between the education programs and treatment. And treatment now is done online many places on Zoom, so people can still be doing treatment and still be drinking if they want to. So I think that the follow-up with a PO and how they enforce a recommendation is very important, because to me the biggest deterrent is this person cannot drink and this person should be doing testing while in probation. Because it says if they don't follow up a full, it says on the bottom I put in there that they will have to do a inpatient or outpatient treatment if they don't follow up the recommendations. Which I'm not the one to enforce, because I can't enforce those, but probation.
The final question, with the one-day anger management class, cost on that, and if it's by Zoom, what's the wait time to get into that type of?
That one is done once a month, and it's a one-day class on a Saturday morning. And that class is being used someone who had either an anger management incident that was not a family member. A lot of the domestic cases end up there, and sometimes it's not my decision to do, because they get referred to the class. It started as a bigger problem. When they go to court, it gets split down to a disorderly conduct, and they ended up in the anger management class. Sometimes I think those people would need more, but they do. And I always make sure when I talk to the probation that if this was not a domestic case, because the domestic cases needs to go to the domestic classes, because that's what court was said. If not, they do the one-day class. It was an incident outside of the family. Or I got a person from Wisconsin yesterday, stopped in the office and registered for that, for example. He's going to be doing the class in April 13, which is the next one. So once a month we do the anger management classes, yeah.
I guess I lied. There's one more question then. On that, what is taught during that class? What is kind of the goals? And how long is that class then?
The one-day anger management class is the shortest one. It's a 6-hour class, 8:30. It goes until past at 1:30. That's what I always make sure that if it has to meet the criteria for the class, like what will be the minimum charge. And it talks about behavior modification, anger management, how to coping with skills of self. I'm trying to read through the curriculum, but it's anger management. We talk about being responsible for your own behaviors, how to minimize some of the situations, and then we talk about emotional abuse, the physical abuse part. We go through. I have a wheel that I use for training that we use from the Duluth model for domestic abuse, but it talks about emotional Because the anger management class, the title should be anger management and emotion, how do you title it? Coping with emotional skills. I forgot the name. I teach the class about 1,000 times. I know it by heart. And somebody else helps me with the class right now because I can't be doing this 24/7. But yeah, in self-control, emotional control, and it's mostly all men. So we talk about, the whole, we role play some situations, office situations, that are real situations that people that got to the class, and we talk about what was the action, what was the meaning of the reaction, and we talk about minimizing what happened, and we go through about the whole situation, talking about that. But there is mostly about emotional control. That's what the class is taught. I mean, there is a 4-page thing that we cover in the class, and if I wish I can put them up there and show it to you, but yeah.
But as I understand, you do distinguish between domestic violence assessments and anger management assessments.
Right, because what happens is the defense attorney gets to me and says, well, let's get into the anger management class before we get to court. So I do whatever the client requests. Then it gets to court and says, wait a minute, this was a domestic case and it was court ordered for a domestic thing. So the outcome of the domestic assessment and anger management assessment are two different things. And I don't want people to waste their time and their money, something that I know later is not going to cover their court requirement. So I said, make sure, was this a domestic or was this an anger management?
Yeah.
And sadly, I'm going to tell you that a lot of those anger managers were domestic cases. He got pleaded down to a misdemeanor offense with disorderly conduct, and now they're only doing a 1-day class. And I'm like, I have to do what the client comes to do, but I don't think this doing much for this person. I let the PO know. It's just because it was pleaded down from the court. And sometimes, a few times, you have someone who had a felony domestic, and now he got pleaded to disorderly conduct and doing a 1-day class, which I don't think it really. A lot of the people who was in the incident with George Floyd in Minneapolis, they did some kind of assault. It was a felony. Suddenly got pleaded to a domestic disorderly conduct, and now they're doing a 1-day class. And I was like, I can't. It's not my judgment to say because I'm just doing whatever the request is. So that's why I'm trying to be very clear with the referrals. If it was domestic, because they go back to the court order. Because otherwise, it's just wasted time in a class, and they're still going to have to do a domestic class. Yeah, but I will give you that information. Just feel bad I can't have all the details on the. I've been teaching class in about 6 months now, so. And this is my first meeting in 5 months. I'm glad to see people here. I'll tell you that yesterday was my last day of chemotherapy. I was given the blessing to go and start working. It's mostly all gone, so just being around people today is very happy. Yeah. Been isolated for like 5 months.
Thank you. Any questions, further comments? Thank you, and yes, Judge Norstrand.
So we need to be mindful of here the statutorily mandated AODA process and the fact that the county is the only provider allowed under the statute for certain types of assessments. In other words, I know the reference to the cost is an important factor, and we've had meetings about that before. The county charges for assessments $380, $150 sounds like a good opportunity. But I would also, and I'm going to leave it to Corporation Counsel to figure out where the lines are here, but we do know there's a type of assessment that's mandated in certain court cases, like OWIs, where the assessment can only be done by a single provider in the county that the county designates. And in this county, the county's designated HHS to do that. So in, for example, Dunn County, I think it's Arbor Place, but we went through that whole process of trying to when there was a backlog of trying to get other providers to do those assessments, and it was not allowable. And that doesn't mean there aren't lots of assessments for able social services to do, but I don't know where the line is. I just want to make sure that we're aware there is a line, okay?
Yeah, and I know it is. This is why I used that, and I don't know if it was allowed or not to use. So there's one assessment is called AOD, and there's a AODA. And even the Minnesota assessment that I used, it covered the 6 criteria of the dimensions of alcohol, mental health, recovery, because they're all under the American Medical Association for whatever. And each state has their own assessment, but they all cover the same dimensions, it meets the same criteria. But I know for someone who lives in Wisconsin, the AOD has to be done in order to insurance, because they leave the jail, and now without that assessment saying that they qualify for that treatment, the insurance won't pay for it. And I know it's probably just very expensive to do treatment without insurance. Well, thank you for having me. Thanks, Phil.
Thank you very much, and continued good health. Next will be our subcommittee reports. Executive committee, there's not really a lot to report on other than we generate the agendas and try to triage, whatever immediate issues may be out there. Our next meeting is on April 25, and again, if anyone wishes to attend, you're always welcome. We generally meet in my courtroom at noon. Criminal Justice, Judge Waterman.
I will report on one item, and that has to do with non-appearances in court. So anytime somebody is charged with a criminal offense, a judge will set bond or bail. Most people charged with criminal offenses are released from jail, either on cash bail or on a signature bond. And one of the conditions of their release from custody is to return to court, among other things. The non-appearances in court affect the justice system in many ways. I mean, it's obviously a delay, but it's also a delay in accountability. It's a delay in justice. Judges have an interest in closing cases, as do the attorneys. Victims want to have closure. We want to get restitution paid, so on and so forth. So delays can be a problem. Justice Services is tasked with identifying people who are likely to fail to return to court. They produce, for intake, I had one printed out, but a pretrial risk assessment, which scores the likelihood of people failing to return to court. And for those who are higher risk, we place them on a monitoring program, which helps to ensure return to court and maintain law-abiding behavior. And the population that is typically referred to a Justice Services monitoring has a failure to appear rate of 70% or, I guess, lower. So more likely that they would not return to court, 70% being the highest. Justice Services staff has been keeping track of some data, and I think this is a noteworthy item. Those that we refer to Justice Services for monitoring have a 91% return to court rate. So, without Justice Services involvement, at best 70%. With their involvement, it's up to 90%. So I think that speaks to their work and the things that they're doing. They are also looking at the effectiveness of the devices that we use to bring people back into court, because ultimately that's what we want. We want people to return to court and be back into the system. Judges will utilize bench warrants, stayed warrants, and other devices to try to encourage people to come in. And one of the topics that we're looking at now in our Criminal Justice Subcommittee is the advantages and disadvantages of these different types of devices. Because anytime we have an executed warrant, it can be costly in terms of the clerk's processing time with paperwork, law enforcement having to go out and make an arrest, bring that person into the jail. Now we've got a law enforcement officer off the street when they could be doing law enforcement functions. The court time, the booking time in the jail, it all adds up. Not to mention it can be dangerous. Anytime an officer is putting hands on an individual, there's a chance for violence or physical confrontation. So we're looking at the effectiveness of stayed warrants, which are a reduced form of warrant to encourage people to come back into court. We're looking at ways that individuals can satisfy or quash their warrants short of actually being booked into the jail and being arrested. So Shelby Hilden and Tina Sitz have been conducting some informal studies and coming up with some numbers. We've got some data right now about what we're doing, but there's more to come in terms of the effectiveness and recommendations about what to do. That's my report.
Questions of Judge Waterman? Thank you. Child Welfare, Anjali Patel, who chairs that subcommittee, could not be here this morning, so she did pass on some notes. I think you'll recall we formed that subcommittee in October, and the committee has met 4 times since then. Our next meeting is on March 28th. It is a group of what I would describe as very passionate people relative to child protection, juvenile justice issues. They've taken on a number of tasks and hopeful outcomes. One was developing policies, which probably doesn't come as a surprise, to deal with testing for parents in child protection cases. And so they've developed those policies and protocols with justice services, confidentiality, reporting, things like that. And so that was one of the tasks that we can check off that they have accomplished. We're going to now start tracking as well parents who are testing and the outcomes associated with that, how many people are relapsing, how many parents are able to maintain programs associated with testing. We're working with our municipal courts and primarily Sue Garrity in terms of early intervention regarding truancy issues, which continues to be a significant issue for many of our school districts, and how we can effectively again, intervene and make sure kids are in school, make sure parents are engaged. Along those lines, ADA Aaron Domro, who is the primary Assistant District Attorney associated with juvenile justice, which is delinquency, is looking at ways to hold parents accountable when it comes to truancy, especially at the elementary level, where parents, for whatever reasons, are not engaged in making sure their kids get to school, making sure their kids are involved and participating meaningfully in school. And so he's working to try to figure out how we can effectively encourage parents to be part of the process and involved in the truancy issues. There was some discussion about exploring a one judge, one family model for child protection cases, delinquency cases, and family cases. That's a little more challenging task because it involves a lot of scheduling issues and how we currently assign cases to the judges in the county. Our family cases are all assigned randomly. When they're filed, it's assigned by a computer. Whereas child protection and delinquency, if you're on intake, those become your cases, and trying to figure out, is there a way to, if I've got the divorce case and parents are involved in the child protection arena, would it make more sense to have me do that child protection case as part of the family law matter? But again, that one is probably going to take a little more discussion as well as development. And then finally, things that we're looking at and working on is parent guides for parents who enter the child protection system. They oftentimes come in unrepresented. We don't have the ability, or the public defender does not have the ability to appoint 4 parents in child protection, which is different than when I started my work as a judge. Public defender did appoint for parents in child protection, and then that was taken away. I think there's still 5 pilot counties where that is still being done. St. Croix is not one of them, but as you can imagine, the cost for implementing that again may be prohibitive. So parents come into the system really not knowing anything about what's going to happen, what to expect, and so we're trying to develop a guide just as an assist for parents to have when they enter. We're looking at revising our local rules for truancy. The last iteration was in 1997, so I think it's time to look at those local rules associated with truancy. Also, we're exploring parent questionnaires. Every 6 months in a child protection case, the judge has to hold what's called a permanency plan hearing for kids who are placed out of home. And so there are some counties that have developed questionnaires to send out to parents in advance of those hearings, so that in a anxiety environment, meaning a courtroom, parents can fill out those questionnaires and then bring them to court, which might be very beneficial because now we simply ask them during a hearing, you know, what do you think needs to be done? What are you doing? Why aren't you doing this? And it, again, is an environment that's not always conducive to those types of exchanges. So we're looking at a questionnaire to assist parents, again, with child protection and primarily permanency plan. So next meeting, as I said, is March 28th. If you have any interest, certainly attend. If you have any agenda items, let me or Anjali know. Any question on child protection? Treatment court, Judge Norstrand, anything else to report out?
I think we're good.
Thank you. Their next meeting is April 10th, as I understand, at noon in Judge Norstrand's courtroom. Domestic violence, Phil.
Sure, Judge Vlack couldn't make it, so I'll just provide a quick update. We had our last meeting January 31st. We had a representative from Our Family Wizard, Commissioner Heckman, referred this individual about some of the work that they do. So she came and gave a brief presentation. It was well received. Our next meeting is on Wednesday, April 24th at 11:30. We normally meet in here, but there's a administration, I think, meeting going on. So we'll be down the hall in 1700. The DA's office will be giving a presentation on how they process domestic violence cases at that time.
Any questions on DV? Behavioral health, Bob.
Yes, thank you, Judge. The Behavioral Health Subcommittee last met on January 22nd, and our next meeting is next Monday. An agenda will be coming out later today for that meeting. Last time we met, we focused on a grant application, updates on a grant application that actually Amber Hahn, Assistant District Attorney for Fond du Lac, is assisting us with, along with partners within the Behavioral Health Subcommittee. This is a grant called the Abuse in Later Life Program, and it would provide us with enough funding to potentially add a position in our APS, our Adult Protection Services area, to help coordinate and assist people over 50 in relation to adult protection cases. So that grant is due, I think, in May. As I said, Amber has really taken the lead on this. We discussed updates. We had updates on our white paper work group. That's an effort to analyze and research our current system of care for justice-involved people who frequently utilize emergency health care or crisis health care systems and or frequently visit the jail. And the idea there is to look at our current system of care and points within that system and make recommendations for how to improve or enhance our response to people who frequently end up in emergency departments, crisis services, and or jail. That's ongoing work, so I'll just have to keep you updated on that. And then we spoke about our behavioral health division. We gave some updates there and some current co-responder data as to how their efforts are showing up in outcomes. And I think the last thing was Phil spoke about the medication-assisted treatment and substance testing. And our meeting Monday will likely involve a discussion around the closure of Health Sisters hospital systems in Eau Claire and the Ellie Phillips Withdrawal Management Center in Eau Claire. Both of those closures are happening tomorrow. The date has moved up a month. So I think that's all I have, Judge.
Which will obviously have a significant impact on western Wisconsin as well. So we'll look forward, Bob, to any information that you can gather or provide and how those voids are going to be filled. Any questions of Bob about behavioral health?
Bob, just real quick, did you want to mention the symposium that's taking place?
Yes, we're having our third annual mental health symposium on May 1st from 5:30 to 7:30 at St. Croix Central High School in the auditorium. The topic is going to focus on emerging adults with mental health and substance use issues. Really, this evolved out of the concerns that were raised after recent deaths by suicide in UWRF. of young people that were facing obvious challenges there. The hope is that we can describe some of the pressures and stressors that are affecting young people today that might be different or have evolved in some way, and elucidate that, and then come up with, through partnerships with the schools and colleges and other professionals, provide some resources and some options, support, other kinds of positive things that people can do to affect this kind of trend that we're seeing. So that will be, again, May 1st, St. Croix Central High School, 5:30 to 7:30 p.m. And everyone's welcome to come. There's no charge. Thank you.
Thank you. Any other questions of Bob? That completes our formal agenda. Again, we're always looking for ideas from this group for future agenda items, so if you have any thoughts or suggestions, pass them on to anyone on executive committee or through Phil. Announcements and correspondence. I think many of you are aware that Judge Garrity is retiring from her responsibilities as municipal judge in Hudson after many, many years of service to the community. And when I talk about passions, I think I can describe Judge Garrity as being passionate about her work in that particular area, and she's been a leader in the state, a teacher, was and I think continues to be the liaison for the 10th District, advocating for municipal courts and the needs of the courts as well as judges. So we thank her for her service as a municipal judge, but also for her tenure on this body. I believe there's only one candidate on the ballot, and that's Kyle Schaefer, is that correct? And Kyle is an attorney with the Willow River Law Firm. Kate Avalos is our vice chair of this group, and he is a partner with Ms. Avalos. So we will, in all likelihood, extend a welcome to him as our municipal judge representative. But I hope, Sue, you stay engaged with our Child Welfare Committee, as you've, again, been very active, and we look forward to that work. So, again, congratulations on your retirement. Finally, election is on April 2. I remind everyone to exercise one of those fundamental rights. And then finally, I should have welcomed Ellen, who is here from Western Wisconsin Health, the representative for Ms. Peterson, who could not be here today. And I think we all know that Western Wisconsin has really stepped up in terms of their involvement and engagement, not only with this group, but in the county and in offering services. So we welcome her on behalf of Ms. Peterson. Any other announcements or correspondence? Hearing none, we are adjourned. Yes?
Well, just one more thing I will share at the English part of my foundation. And when you mentioned the increase of the Spanish families that are moving into the area, just to remind you that as I've been doing the assessment, a lot of people are coming in, they're working in farms and other areas, and most of the times they're getting. And it's not only the language barrier. When I do the assessments, I talk about how to get the education and the data. So people that went to 6th grade education and then they went to work in farms. So and a lot of people that are coming from southern Mexico, Guatemala, the people that have been doing a lot of assessments. People that only went to 6th grade, and Spanish is not even the first language, so it's a big comprehension. And even when they're given the forms, I think once I help them with one thing, I spend quite a bit of time because they keep coming back to me from the beginning to the end of the process, so I do spend quite a bit of time with it. Not just the language barrier, it's a whole comprehension, being new to the whole system, so it can be very confusing. There's quite a lot of people that have been seeing them moving along the river all the way down to Colorado, Minnesota, County, Alma, and all that.
Thank you, and that comment kind of hits home because I've got a pending, very serious domestic violence case involving a victim who our interpreter said, Judge, she needs more than just interpretation services. Her education is less than 6th grade, and this entire process is not in any way familiar or within really her realm of understanding. So that hits home, and so we're trying to work with her and trying to find someone who can provide that additional support. So.
Facilitator that helps me with that class, he's from Argentina. He was a psychiatric doctor down there. He cannot use his license here, but he's very experienced. And people get a lot out of him because, he has, although he can practice clinically here, but he has a lot of experience.
Thank you. And then finally, we'll make sure we'll get Phil a new placard before the next meeting. We're adjourned.